2016-282, State of Arkansas versus Tamara Thompson.
Your Honor, Ms. Thompson, although new to us, I did have the chance to visit with her yesterday. I believe this is actually on the court's revocation docket, unless there's a new charge that I was not aware of.
This is a new charge. This is a new charge for possession of a controlled substance, methamphetamine, Class D felony. The charge was filed, the file was set up on August 31st. And alleges behavior on August 30th.
Your Honor, we've been under a plea of not guilty and waive formal reading of the charges in this matter.
PD is the Public Defender's Office is appointed. The plea of not guilty is noted. Let's see. I believe the date of arrest is August 30th. Let's see, is there also a case on the revocation docket coming up today?
Yeah, there's not going to be one revocation docket. There's a pending revocation out of Pennsylvania, and we're not going to address that this time.
All right.
There's no holdover.
Court's going to set this matter by scheduling order. This will be for reappearance on February 23rd, 2017 to check the status of the case. A March 23rd pretrial date and an April 24th, week of April 24th trial. So that case will be set by scheduling order. Now, so, anything further to come up on this case?
Your Honor, Ms. Thompson, in talking with her yesterday, raised the issue that's been raised by her mother, who approached me in the courtroom prior to court starting, also about rehab. And they specifically mentioned John 3:17. Your Honor, I would move at this time that if she qualifies and is accepted by John 3:17, that she go to John 3:17 on the court's usual stipulations, that she goes straight from the jail to John 3:17, and that if she would leave John 3:17 prior to completion or not do anything that she is supposed to do with that program, she immediately returns to jail.
Well, what the court's going to do is at this point, I'm going to leave the bond. It's currently set at $5,000. I'll leave it there. Once she is accepted into John 3:17, and it's my understanding, in order to get accepted there, she's going to have to get herself out and make application, and she's going to have to go through a system of screening by them over, actually attending their program out of state. I'm not sure how she's going to do all this. I'm not going to let her out to get into the program. If she can make the arrangements to get accepted to the program and wants to approach the court about making that arrangement where we essentially OR her out to the program, I'll be more than happy to do that once she's accepted. But at this point, in order to get accepted, she's going to have to go to the state of Missouri. Go out of state is what my problem is, I think.
There's actually a facility now in the state of Arkansas.
Okay.
317.
Well, it just concerns me. She's, in order to get into the program, I think she's going to have to get herself out on bond, subject to a bonded arrangement, and then, get into the program, and we'll proceed on that basis. So, I'm leaving the bond at $5,000. If she can get into that program, and we need to adjust anything, I'll be glad to do it to make sure she gets an opportunity to successfully complete that program. But I'm not willing to just let her out to see if she's going to get in.
Judge, that was not my request. Your Honor, I've not dealt with John 317 near as much as I have John 316.
Okay.
I think John 316 will actually come to the jail. I think John 317 will, but I do not know that for sure.
Okay.
Your Honor, that $5,000 bond, that is cash or pro, is that correct?
Cash or pro?